Hazelwood v. Kuhlmeier, 1988. Does the decision of a principal to prohibit the publishing of certain articles in the school newspaper, which he deems inappropriate, violate the student journalist's First Amendment right of freedom of speech? In 1983, students in a Journalism II class at Hazelwood East High School were responsible for writing and editing their school's newspaper, The Spectrum. In May, the school's principal, Robert E. Reynolds, received the proofs for the May 13th issue and found 2 articles to be inappropriate for school. The controversial articles discussed the topics of teen pregnancy and the impact of divorce on students at school. In the article on teen pregnancy, students shared their experiences and opinions on the topic, but the girls' names were changed to protect their identities. The article on divorce discussed one student's experience with her parents' divorce, while depicting her father in a negative light. The principal forced the students to remove the articles. With the printing deadline quickly approaching, there was no time to edit the paper, causing entire pages, including unobjectionable articles, to be eliminated from the final edition. One student, Kathy Kuhlmeier, along with 2 others from the class, brought a suit to the U.S. District Court of the Eastern District of Missouri, claiming their First Amendment rights of free speech had been violated. In district court, the school argued that Reynolds was justified in his decision to remove the articles. The principal believed that simply changing the names of the girls in the pregnancy article did not ensure their anonymity, and in general, a feature discussing birth control and sexual activity was not appropriate for younger students. On the grounds of journalistic fairness, Reynolds stated that he thought the father in the divorce article had a right to be informed of the article's existence and given a chance to comment before it was printed. The district court ruled that Kuhlmeier's First Amendment right of free speech was not violated. Siding with the school, the court ruled that the school had the authority to remove articles written as part of the school curriculum. However, the issue did not die in district court. In 1986, the students took the case to the U.S. Court of Appeals for the Eighth Circuit. The court decided that the Spectrum was considered a public forum and was intended to be and operated as a conduit for the student viewpoint. It ruled that the school could not censure the paper unless it was necessary to avoid material and substantial interference with school work or discipline or the rights of others. Still, the issue did not end there. Hazelwood High School officials, unhappy with the most recent ruling, appealed to the Supreme Court. Due to a conflict of law, meaning lower courts reached different conclusions about a federal issue, the Supreme Court justices decided to hear the case and issued a writ of certiorari. On October 13, 1987, the case of Hazelwood v. Kuhlmeier began proceedings in the Supreme Court of the United States. After reviewing the briefs submitted by each party, the decisions of the lower courts, and oral arguments, the Supreme Court was ready to rule. In a 5-3 decision, with 1 vacancy, the court held that the First Amendment did not require schools to affirmatively promote particular types of student speech. By refusing to sponsor speech that was inconsistent with the shared values of a civilized order, educators did not offend the First Amendment by exercising editorial control over the content of the paper. The court overturned the Eighth Circuit's decision that the paper was considered a public forum, saying that it was a limited forum for journalism students to write articles pursuant to the requirements of their journalism class and therefore subject to appropriate editing by the school. The breakdown of the decision was as follows. Rehnquist, Stevens, O'Connor, Scalia, and White, who was chosen to write the opinion of the court, were in the majority. Brennan, Marshall, and Blackmun were in the minority, with Blackmun writing the dissenting opinion. Why was this case so significant? The decision in Hazelwood v. Kuhlmeier began a new trend in the rulings of First Amendment cases. During the 1960s, an era of student protest, publications exploring social issues such as civil rights were common and accepted. In 1969, the Supreme Court upheld that the freedom of expression of students is protected under the First Amendment in the case of Tinker v. Des Moines. At least 125 additional court cases around the country were decided in favor of the students during this time period due to the legal precedent set by the Tinker case. The decision in Hazelwood v. Kuhlmeier, as well as in Bethel School District v. Fraser in 1986, allowed school administrators to begin to reassert their authority in public schools. This shift in decisions reflected a shift in leadership and culture during the 1980s. The conservative Ronald Reagan was in office and appointed Justice Rehnquist to the Supreme Court, the Chief Justice from 1986 to 2005, also a conservative. Rehnquist succeeded Chief Justice Warren Burger, who, although he identified as a conservative, had made many liberal rulings on topics such as abortion and capital punishment, including the Tinker case. The court's decision in Hazelwood v. Kuhlmeier struck a devastating blow to scholastic journalism, significantly cutting back on the First Amendment protections of public high school students. This decision would set the censorship guidelines for many years to come, and to this day, continues to govern what can and cannot be printed in schools.